In one of the early videos for this class, Professor Mystic talked about mens rea. And he also talked about what happens when there is the absence of mens rea. He noted that actus reus plus mens rea equals a crime. And it certainly can. Assault is the intent to cause physical bodily harm plus reasonably bringing someone into apprehension of that bodily harm. Murder requires actus reus plus mens rea plus a death. But when you have actus reus plus mens rea, most of the time you will have the elements of some crime. Very few crimes other than homicide actually require harm to be done to constitute crime. Possession of drugs, the most commonly prosecuted thing in our criminal justice system, rarely requires anything beyond possession and the intent to the knowledge of possession or the intent to distribute, actus reus plus mens rea. We look today at one of the examples, though, that he talked about in that video, looking at the elements of an offense, the actus reus and the mens rea. He mentioned in that video that there are times when mens rea is not included, and that those things are called strict liability offenses. And for strict liability offenses, this means that the fact that the defendant says this was an accident and can prove it, that's of no consequence. If a crime doesn't require the person to have a culpable mental state, if the statute does not require the person to act intentionally, knowingly, recklessly, negligently, then what the statute is saying is, we don't care how you came to do this thing. If you do it, you are guilty of a crime. Now, that sounds harsh. That sounds contrary to everything you are intuitively trained to believe about the criminal justice system. And so those things are also very rare. And this case talks about the types of examples when that will actually happen. So let's talk about this particular case. The question in this case is whether Minnesota has created a strict liability offense for the unlawful possession of an unregistered weapon. And so in this case, there's a lawyer, he's going to court, and when he goes through the metal detector, they find a weapon in his briefcase. His defense is that his wife packed the gun in his briefcase and didn't tell him. And he had no reason to know that she would do it. Now, could a jury find that that is a highly unlikely story and that he either put it there or he knew it was there? That what are the odds that the wife put the gun in the briefcase? Sure. But the question we're looking at in this case is, was the jury required to find that? Or was the jury allowed to find that however the gun got into his briefcase, whether he knew about it or not, he's committed a crime by virtue of the fact that it's there? Does he have to be aware that it's there? Does he have to be reckless for not checking to see if it's there? Does he have to have some reason to think his wife packs his gun for him? Or could it be that completely unknown to him, she put it in his briefcase and he's still guilty of a crime? The judge instructed the jury that they didn't have to find that he was aware that it was there, that he was reckless with regard to the fact it could be there, that he was negligent for not thinking his wife could have put it there. If it's there, according to the way the court instructed the jury on this, if it's in his briefcase and he tries to go into the courthouse with it, according to the way the court instructed the jury, that's enough for a criminal conviction. The court was essentially saying this is a strict liability offense. So what is a strict liability? When does a legislature create such a thing and how? Well, the first thing a legislature has to do is leave out a mens rea term. If it says intentionally or knowingly, then that's what has to be proven. That he had to be aware, that he had to intend to, that he had to be reckless, depending on what the statute says. But the mere absence of a mens rea term, like intentional, knowing, reckless, is not the end of the story. The court will assume or presume that the legislature meant to require mens rea because we're hardwired to believe that a crime requires a person have a culpable mental state, reckless, knowing, intentional, negligent, or some other variation of words that we'll get into later in the semester. So if we're hardwired to think that, when do we assume the legislature's absence of one of those words was what the legislature actually meant? Well, the court in this case tells us that there are two things that clue us in on this. What is it that the statute is regulating? And how hard is it punishing? So let's take the second first. If this is a very harsh penalty, if it's a felony, for instance, if it carries more than a year in jail, if it carries several years in jail, then we assume that is something that absolutely has to have all the components of a traditional punishment or traditional crime, namely mens rea. So let's say that the punishment is relatively light, as it was in this case. It was a misdemeanor. Is there anything else we need to consider? Or do we assume the legislature provides for no mens rea when they leave it out and it's a very light punishment? And the court says, no, that's not all we look at. We also look at what the statute is regulating. If it is regulating what's called a public welfare offense, meaning something that would cause a great deal of harm to a lot of people from a little bit of conduct. Pollution is an example of this. If you let pollutants get into the air, or if you identify, if you say this is aspirin and it really is rat poison. Well, a lot of people could be harmed from your small act. And so the court in those types of circumstances, they call them public welfare offenses, when a great deal of harm could come from a small act, and we don't punish it that harshly. The court says that if the legislature leaves it out in that circumstance, we do think they probably meant to not require mens rea, and so that won't be required for a conviction. Well, is gun possession in public a public welfare offense? Well, as you might imagine, that's an issue that's hotly contested. Some judges say guns are dangerous, and therefore possession of guns are things that could harm a great deal of people, and so yes. Not surprisingly, other judges say it's not guns that are dangerous, and you're allowed to possess a gun under certain circumstances. The lack of getting a license is certainly not the thing that makes you dangerous, and people kill, not guns. This particular judge was in the category of saying that guns themselves are not dangerous and they can be lawfully possessed. And so this court was in the camp that gun possession under unlawful circumstances, failure to have a license, etc., is not something that is inherently dangerous, and therefore this is not a public welfare offense. This court also noted that while it was a misdemeanor, the legislature provided that repeated convictions for this could be a felony. And so there was a potential for substantial punishment that attached. So the key thing to take away from this is when the legislature leaves out a mens rea term, we presume that they actually meant to leave something in, and the court will fill in the gap and put in that thing which makes the most sense. Here, knowing or reckless, as the court did in this case for the felony conviction or for the felony count for which he was acquitted. But there are times when the court says we actually do think they meant to leave it out. We won't fill in the blank term. We won't fill in the missing term. We'll assume they meant to leave it blank. And those are times when the punishment is light and that the activity regulated is one that would cause a great deal of harm, potentially, to a large group of people.